ICC 0109-0111. We are in open session.
Thank you. Appearances.
Good morning, Your Honours. For the prosecution, lead counsel Anton Steinberg is back today. Otherwise, the team remains the same.
Good morning, Your Honours. On our side, our team remains the same as before. Thank you.
Good morning, Your Honours. Mr. Sang's team remains the same, and Mr. Sang is present.
We are the same, with the exception that Mr. Khan and Mr. Essafal are not present at the present. Thank you.
Thank you. Mr. Kiginkato, today you begin your cross-examination, but before you start, there was a question I asked the prosecution. Mr. Garcia, as I said yesterday, on Friday, towards the close of the proceedings, just so we understand the point being made, we have a witness on the stand who had been subpoenaed to appear, and on the basis, of course, of the statement the witness gave to you, implicating the accused subpoenaed to appear, and on the basis, of course, of the statement the witness says that everything that's in the statement was by an investigator and an OTP trial lawyer. You have vigorously cross-examined the witness, attacking his credibility, especially on that account. The Ruto defense in their cross-examination get up, attack the witness's credibility on other accounts, and again returns to the allegation made against the OTP. Mr. Hooper made it very clear on 2 occasions. Fans reject the witness's testimony that it is the OTP effectively that put those material in the witness statement. They made it, Mr. Cooper said that quite clearly. They do not accept that from the witness. The question then becomes, what do you want to do with the testimony of this witness?
Your Honours, if I may speak to that point, this is a matter which I suspect will not be unique to this witness. The starting point in my respectful submission is that this and several other witnesses gave relevant and incriminating evidence upon which the prosecution relied, both in the confirmation hearing in certain circumstances, but certainly in drafting the charges which the accused currently face. The prosecution will argue that the reason why this witness and various other witnesses have ceased cooperation with it, and in many cases have recanted their evidence, as with this witness, is because in the intervening period between giving their original statements to the prosecution and being called to testify, they were subjected to improper influence, which has materially affected their cooperation with the prosecution. As with this witness, is because in the intervening period between giving their original statements to the prosecution and we can take the matter no further, would be to give in to the forces which are, we say, directly and concertedly trying to derail the prosecution case and assist in evading what we say will be justice. Now, The prosecution would obviously prefer to go forward with to call witnesses, to lead their evidence, to have their evidence tested as it should be, and then to have Your Honours reach a decision. But in the circumstances, that is not possible. The prosecution therefore seeks to avail what remains, as we say, an option, or we will argue as an option, in the circumstances where these witnesses, if we can establish that there has been improper interference, we see a sound legal basis in the statute and in the rules for the admission of their prior statements as proof of its content. Now, the prosecution will submit that it would not be in the interest of justice for the Chamber not to have this material before it to consider what weight, if any, it is to give to this evidence. Should the Chamber ultimately review these statements and conclude that no weight or little weight should be given to them, well then the prosecution will have done its job, and with respect the Chamber will have done its job too. But we submit that the Chamber should at least have that opportunity. And the fact of the improper interference, if established, the prosecution will argue, is an indicia of the reliability of the witness's earlier testimony. Because experience and common sense dictates that one doesn't go around bribing witnesses who do not have cogent and dangerous evidence which the accused would have to meet. So the purpose, what do we do with this testimony, Your Honours? Your Honours, we submit that the Chamber takes into account this testimony, do not have cogent and dangerous evidence which the accused would have to meet. Rejected, and considers what then to make of the earlier statement. We say that the earlier statement should be admitted and should be considered by the Chamber.
Just to be very clear, there is not at this stage indicating any views on the testimony. We just want to be sure what the prosecution intends to do with the testimony of this witness. Is it your position that you will be insisting that the original account given by the witnesses, or this witness in particular, in his statement, is a correct version? Is that what you're saying?
Yes, Your Honour, in a nutshell.
Then we leave it at that. Thank you. There will be no debate back and forth on this, and Mr. Kiginkatwa, proceed and let us know, Mr. Hooper, not on this matter. We're not.
Understand, and I'm
Yes.
not going to. My particular difficulty with Mr. Kiginkatwa, and it merely comes to this: that there's one matter that I overlooked to put on Friday. It's a matter that will only take minutes, and I overstepped it in my determination to conclude. And with the Court's leave, I'd like to have permission of the Chamber to ask just a few questions. It will take no more than 5 minutes at the most, very most.
All right. Let's bring Mr. Kiginkatwa.
Mr. President, and especially in view of the absence of the witness, may I indicate that our team shares the position taken by Ruto team in respect to the conduct of, or rather the collection of this statement. Most specifically, it is our position that we do not share the witness's position that it is the prosecution which of the witness. May I indicate that our team shares the position taken by Ruto team in respect to the conduct of, or rather the collection of this.
Mr. President.
While we're waiting for that, may I just indicate that I'm grateful to my learned friend, Mr. Sang, for that concession too.
Mr. President, the witness has entered the transmission room.
Thank you very much. Witness, welcome back to the stand. Mr. Keegan Katwa was going to start immediately. He will still be asking you questions a little later, but for now, the chamber would allow Mr. Hooper to ask more questions that he had forgotten to ask you last week. So Mr. Hooper will some more questions. Thank you. Mr. Hooper, we are in the open session.
Yes. Good morning, Mr. Witness.
Good morning, Your Honor.
Now, I only have just literally 2 or 3 minutes I want to spend with you this morning, as His Honour just said, in respect of a matter that I overlooked to ask you last week. As it concerns a particular place that is identifying of you, perhaps, I'd ask that we go into a private session.
Private session.
We are in open session, Mr. President.
Now, I would like the court officer in Nairobi to show you that document, Ken-OTB-0095-0755, being the screening notes, and it is in our tab 2 of our bundle.
Document Ken OTP 0095-0755 is presented to the witness.
Now, witness, I would like you to be shown paragraph 3, headed meetings. Can you see that, Mr. Witness?
Yes, Your Honor.
Now, the second last paragraph and the last paragraph in that page shows 2 meetings. Can you see that?
Yes, Your Honor.
Now, I know we are in public session, but I can mention you had said that there was a meeting on the 23rd in the 2 locations I asked you about. And my first question is, could you confirm that in fact in your screening notes you had not made any reference to that meeting of the 23rd, the 2 meetings on the 23rd? The first one in a stadium and the second one in a private location.
Yes, Your Honor.
Do you have an explanation why you had not made any mention of that meeting, Mr. Witness, in that initial interview?
I never attended any of these meetings, Your Honor.
Could you also confirm that in the entirety of your statement, in the entirety of your screening notes, you did not mention Mr. Sang anywhere whatsoever?
Yes, Your Honor.
Now, I want to move on to a different issue. At paragraph 50 to 56 of your statement, you make reference to some events which, according to you, took place at a location. This is a public issue. Can you see that, Mr. Witness? At paragraph 50. Just immediately above paragraph 50 on the 20th. Can you see that?
Yes, Your Honor.
Mr. Witness, just before I finish that point, before I get into that point, may I ask you, could you confirm that apart from the position that you've just explained that you did not mention Mr. Sang, that you actually made no reference to any rally in that screening notes also?
Yes, Your Honor.
Mr. King, counsel, you pointed the witness.
I could ask. I think I understand. I might have contributed.
Yes, so we don't cross the wires there.
Mr. Witt.
Sorry, just correct the matter.
Yes, Mr. President. Mr. Witness, we were discussing the issue of 2 meetings on the 23rd December 2007, one being a rally, the second one being in a private location. And I want to ask you questions very specifically in respect to that 23rd December 2007. May I ask you the first question? Could you confirm that in fact you did not mention any rally in your screening notes of the in your screening notes?
Yes, Your Honor.
Neither did you mention the meeting in the private location that we've just gone through, isn't it?
Yes, Your Honor.
Now, I request us to go to page 9 of the notes you have of your statement, and that is Ken.
Let's get this right. Which private location are you talking about? I believe that the private location dealing with the accused person's residence was mentioned in public. Wasn't that the case?
I thought it was in private session. I don't know.
I think we can mention it in public, that whether or not the witness was at Mr. Ruto's home at a meeting, and he says no. To that, he's saying so now. Is that the case? That's our understanding.
Yes, may I ask him again?
All right.
Yes.
Do that, and I also look at paragraph 50. I think that location has also been mentioned in public session. And the reason I say that, when you say private location, we do not know whether you're referring to one or the other. So we need to be clear on the record to avoid confusion later on.
I'm obliged, Mr. President. Mr. Witness, we've already confirmed that it is your testimony that, in fact, you did not mention the rally at Kipchoge Keino Stadium on the 23rd December 2007. The other question I'd asked you was whether you mentioned the meeting allegedly held at Ruto's home, Ruto's house, on the 23rd December 2007. Did you mention that in your screening notes?
No, Your Honor.
Now, I want to move on to what is contained at page 50 to page 56, Mr. Witness, being events related to Brookside. Can you see that, Mr. Witness?
You mean
Yes,
paragraphs 50 to 56, you mean?
Yes, Mr. President, I apologize if I didn't come out clear. Now, Witness, could you confirm that the events you've narrated at paragraph 50 to 56 were also not featured in your screening notes?
Yes, Your Honor.
Is that a screening note, Mr. Kiginkatwa? That's one question. And the second question is, does he have it as we speak? My understanding is that screening note is a document prepared by investigators after meeting a potential witness. Isn't that the case? So whether we can characterize it as his screening note.
May I reformat my question, Mr. President?
So it would be in the interview that resulted in the screening note. Isn't that what we're getting at?
Mr. Witness, at paragraph 50 to 56, you've given a narrative of events relating to Brookside. You can see that, isn't it?
Yes, Your Honor.
And these are events, according to you, that took place between the 25th and the 26th December 2007, isn't it?
As it was stated in their statements.
Now, you had just been shown the screening notes at tab 2. If the court officer in Nairobi could show you Ken-OTP-0095-0755.
The document is in front of the witness, Mr. President.
Witness, you can see it is headed screening notes. You can see that.
Yes, Your Honor.
Now, my question is, the screening notes is a product of discussion and interview you had with investigators. And my question is, could you confirm if you mentioned the events of the 25th and 26th at Brookside in the screening notes to the investigators?
Just to be clear, Your Honor, just for the record, and I stated this initially, I think the screening note is actually the product of the investigators, but resuming what had been stated over a phone conversation. So that's the first point. And just as to the way the defense counsel is framing his questions, it should be rather whether he told the investigators at that point this information. This is a screening note, after all. The witness hasn't had a chance to confirm the information that is on it at the time or later on. So it's basically what the investigator's recollection or what they've taken down as notes of the conversation with the witness. And obviously it's subject to what questions were asked to the witness at that particular time. So I understand that there has been a certain amount of cross on that topic, but it can very well be that certain subjects were now broached. I'll limit myself to that at this point.
Mr. President, I can reformat my question so that it accommodates the concerns of my colleagues.
Yes, keeping that in mind, as I had indicated earlier, the screening note is a product of conversations had to interview. So let's, if we understand that, let's just give it straight.
Mr. Witness, on that note that you've just been given, the screening notes, you will see there is a date. Can you see the date on that document, Mr. Witness?
Yes, Your Honor.
Now, the question I'm asking you is, did you mention to the investigators the events you've narrated at paragraph 50 to 56 in your statement, being specifically the narrative about the events at Brookside on the 25th and 26th of December 2007? Did you mention that to the investigators?
No, Your Honor.
Could you also confirm that on the face of the document you do not see any reference to those events of Brookside on the 25th and 26th December 2007?
Yes, Your Honor.
Now, the substance of what you say, and which is relevant to Mr. Sang, is the first sentence at paragraph 50, which I will read, where it is said on the...
We're now back to, we've moved away from the screening notes and back to the statement, is that it?
Yes, Mr. President.
Yes, okay.
Mr. Witness, are you with the, do you have the statement with you there?
Yes, Your Honor.
Now, paragraph 50, the first sentence, I'll read only the first sentence and then we go to paragraph 51. Paragraph 50, you said this: on the evening of the 25th, you said that in the evening of the 25th there were rumors of ballot boxes being transported by monoline buses and 2NK from Nairobi to Eldoret with cast forts inside. You've seen that?
Yes, Your Honor.
And then at paragraph 51 is where you make specific reference to Mr. Sang, that the next morning, on the 26th December at 7 a.m., at around 7 a.m., I had the information about ballot boxes being announced by Sang on Lene Emet, which was Sang's program on Kass FM. I took this to be a warning that ballot boxes were on the way. You can see that?
Yes, Your Honor.
Now, in the course of evidence in chief through the prosecution and cross-examination by Ruto's team, you confirmed that it was in your general nature to read newspapers. Did you say that?
Yes, Your Honor. If I could come across a newspaper, I read it.
You also occasionally watch the TV and listen to the radio, isn't it?
Though I don't have a TV, so whenever I get one, I watch.
Now, could you confirm, Mr. Witness, that the issue of the ballot boxes was the same issue as the subject of administration policemen being used or allegedly being used by PNU in the build-up to 2007 elections. Could you confirm that that was the same subject?
Your Honor, I'm less concerned about the politics, so I don't know exactly the relationship between the ballot boxes, the Brookside, and the police. I don't know.
Do you recall, Mr. Witness, that in the period of December 2007, there were discussions that administration policemen were being used by PNU to rig elections? Do you recall that?
No, Your Witness. I never heard about it.
Now I will play an audio that was a video that was played to you by Ruto team on Friday. I want you to listen closely and confirm if there is any relationship between the allegation made in that paragraph 50 and 51 with what one Honorable Musalia Mudavadi is saying. Mr. President, that the translation is at our tab 9, Ruto's binder, and it is Ken-009-0038-045, being the video which was already exhibited as EVD-T-D09-00261. The translation itself is Ken-D09-0038-0469. We will play timestamp 0034 to timestamp 0048. This is a video of events of the 23rd December 2007.
Tumepata copy ya signal wametuma kutoka Nairobi, signal ya kusema kwamba ati askari wawe wakienda kula, si ndio? Wamekusanywa kila mahali ati watumia kuiba kura
Once again he was calling on
Mr. Witness, the first thing I would request you to do is, if you could summarize to us what you heard Mr. Honorable Musalia saying in the video.
Your Honor, what I've already heard from the audio of Musalia is that the policemen have been mobilized all over to go and rig the elections.
And you recall that you were asked, did you watch that those events, Mr. Witness, those events of the 23rd December 2007 being featured in the video, that rally?
No, Your Honor.
Now, Mr. Witness, I want to ask you, would you confirm that the issue of the administration policemen being allegedly being used to rig elections is the same thing that you have made reference to at paragraph 50, saying that there were fake ballot boxes being transported?
I'm not getting your question, Your Honor.
My question, Mr. Witness, is that at paragraph 50, you said there were rumors of ballot boxes being transported by Molo Line buses and 2NK from Nairobi to Eldoret. And my question is, having watched the video, do you recall or does it occur to you that there is a relationship between the allegations of ballot boxes and the use of administration policemen to rig elections?
Yes, Your Honor.
Now, at paragraph 51, could you confirm that according to you, Mr. Sang announced this issue on the 26th December 2007?
Your Honor, I did not hear. In fact, I had no radio on that day.
Let me ask you this, Mr. Witness. Paragraph 51 says that Mr. Sang made this announcement on the 26th December. You can see that?
Yes, Your Honor. I can see it in the statement.
And you can see that Musalia was making or expressing concerns about it by the 23rd December, 3 days before the date referred to at paragraph 51. You can see that, witness?
Yes, Your Honor.
Two last questions on that issue. It is your position that this issue of the ballot boxes were rumors, isn't it?
Your Honor, I believe they are rumors because in the first case I never heard about it because I was at home.
Now I want to show you a newspaper report of the same date, 26th December 2007. Your Honor, that is at our tab 5, and it is Ken-D11-0010-0125. And it was already marked as an exhibit, EVD 44. I don't know if the court officer in Nairobi has shown you that newspaper cutting. Ken-D11-0010-0125. Hello, court officer Nairobi.
Yeah, Mr. Keegan, I can't find the document. Can I confirm with you the ERA number? Is it Ken D11-0010-0125?
Yes, and it was already marked as an exhibit 44.
One moment, please.
It is a public document in any event, isn't it?
It
I
is,
found
Mr.
the
President.
document. The document is presented to the witness.
Now, Mr. Witness, I want you to look at the first column to the bottom of your left side with the heading Agents in the Night. Can you see that, Mr. Witness?
Yes, Your Honor.
I will read. Please confirm if what I've read is correct. This is what the news. Could you first of all confirm what is that item you are holding? What is it?
It's a newspaper script, Your Honor.
Of which date, Mr. Witness, and which newspaper?
Of 26th December 2007. Your Honor.
Standard newspaper, isn't it?
Yes, Your Honor.
Now, could you confirm this is what it states in the first column? With the elections only hours away, at least 20 civilian buses drove out of high security facility in Nairobi on Monday night. as the Standard and KTN undercover reporters and crew watched. The buses left Embakasi Administration Police Training College, initially at intervals of between 10 and 20 minutes. Later, they left in much quicker succession. Hours later, the destination of the buses and the mission of their occupants became known to TV footage, and still pictures in our possession show the names of the buses and their registration numbers. Several people were said to be APs, were injured at Bida in Super District when members of public attacked them. They were also attacked in Sori in the volatile Nyatike constituency. Can you see that, Mr. Witness?
Yes, Your Honor, I can see.
Now, the first question I want to ask you is this the same issue that you are referring to as being the allegation of ballot boxes at Brookside on the 25th and the 26th December 2007?
Your Honor, I believe it could be the same issue that was there on 26th, though I'm not very much aware.
And witness, at paragraph 50, you said it is rumors. Can you see that it was already featured in the newspaper of the 26th, which according to paragraph 51 is the date that it is said Mr. Sang made the announcement?
Yes, Your Honor.
And lastly, from paragraph 1, could you confirm that apart from Standard newspaper, the issue was also featured by KTN as reported in that newspaper?
I don't know, Your Honor, because I never heard about it in KTN. Neither I never heard the radio.
Okay, I want to take you to tab 6, sorry, and that is, I will request the court officer in Nairobi to assist. It is Ken D11 0014-0211, and it was marked as evidence EVD-T-D11-00045. I would request the court officer to show you page 212.
Document 0211 is before the witness, and he can view page 212.
Now, witness, could you confirm that that is a Standard newspaper report of the 27th December 2007?
Yes, Your Honor.
Now, can you see the heading, calm restored in Nyanza, and then goes on to say 2 APs killed by mob over allegations they would be used to rig today's elections. Can you see that?
Yes, Your Honor.
And then I want you to look at the next column where it is indicated, don't fight APs, Nyong'o pleads with supporters of LDM. Can you see that?
Yes, Your Honor.
Now, I will read the first paragraph and the 5th paragraph. The first paragraph says that ODM has appealed to party supporters to stop attacking administration police officers. And then the first sentence in the next one is, ODM Secretary General Professor Anyang' Nyong'o told supporters to stop confronting the officers, saying their move would affect voter turnout. And then at paragraph 5 it says, unsubstantiated claims have been doing the rounds that APs will be used to rig elections. Can you see that, Mr. Witness?
Yes, Your Honor.
Would you confirm if this is the general nature of the rumors that you have referred to at paragraph 50 of your statement, of the statement?
Yes, Your Honor.
Now, could you confirm if in fact you had Mr. Sang make an announcement, as he stated at paragraph 51, that Mr. Sang made an announcement on the 26th of December 2007?
I never had, Your Honor.
Okay, I want to move into a different issue. Mr. President, I appreciate the time, but the first two questions I'll ask will give me an indication whether I have any more to ask him. Allow me to ask about two questions. Mr. Witness, I want you to be shown by the court officer paragraph 80 of your statement.
Paragraph 80 is presented to the witness.
Sorry, before we go to 80, I want you to go to paragraph 89. If you could be shown paragraph 89.
89 is presented to the witness.
Now, witness, at paragraph 89, this is what he stated. I listened to the radio. I heard that so many areas were being banned, even Nairobi. I was listening to Citizen FM. On Cast FM, it was only music. I remained inside the house. Can you see that, Mr. Witness?
Yes, Your Honor.
Now, apart from hearing music, you say on Cast FM it was only music. Did you hear anything else?
No, Your Honor.
You had music only from Cast FM?
I never had a radio, Your Honor.
So let me just get it clear, Mr. Witness. What do you accept as being the true position of paragraph 89? Did you listen to Citizen FM?
No, Your Honor. I rarely have access to radio, especially by that time. No batteries, so I could not get the information from the radio.
There is the part where you said you remained inside the house. Is that correct? And this is on the 1st of January 2008. I'm sorry, witness.
All throughout, I was within my compound, Your Honor.
What of the statement when you say, I heard that so many areas were being banned, even Nairobi? Do you recall having heard that?
Yes, Your Honor.
Mr. President, I would like to leave my questions there. I think I have no more questions. Thank you, Mr. Witness, for answering my questions.
Thank you. Any re-examination?
No re-examination, Your Honor.
Thank you. Witness, that will be all for you for now. We thank you very much for coming. We wish you good luck we wish you good luck in your discharge from the testimony and also from your subpoena. Thank you. We will take a break now, in which time there will be the transition that will happen between the two witnesses. Call who rise.
All rise. We will
All rise. If we will lever. Please be seated. We will as well.
Thank you very much. The next witness for the prosecution would be witness 516, appearing as a result of the summons issued to him. And in Nairobi, we understand that there is counsel assigned to the witness. Is that the case?
Yes, Mr. President, the counsel of witness 516 is present in the transmission room.
Thank you. Sir, could you kindly state your name for the record?
Mr. President, my name is Wandugi Karathe. Could I spell it?
You spelled it the last time, wasn't that the case?
Yes, yes, Mr. President.
Yes,
Correct.
we have it on the record, Mr. Karathe. We have been informed that you have been provisionally admitted to the list of counsel entitled to represent persons before the court. Is that the case?
Yes, it is, Mr. President.
Is it
And I'm grateful.
Noted. We also understand, is that the case, that you have been given access to the statement or statements of witness 516? Is that the case?
I have been given access. I have been able to go through it.
Thank you. And have you had an opportunity to review the statements with the witness 516?
I have had some time since Friday, Mr. President, but I fear I didn't feel time was sufficient. But I understand the timelines.
You feel what? You
I feel maybe I could have gotten a little bit more time, but I do appreciate the court's timelines.
All right. So
Granted, which I'll do my best.
So you could have needed more time, but you were able to do what you could.
That is so, Mr. President.
Thank you. We note that your role is limited solely to the question of the possibility of self-incrimination by the witness, and to advise the witness in respect of the applicable provisions of the court's basic documents that deal with that question, and also in assisting with intervention that may be needed to be made in that regard in the course of the testimony. Have you had occasion to review those provisions, specifically Rule 74 of the Rules of Procedure and Evidence of the Court, as well as Articles 70 and 71 of the Rome Statute?
Yes, Mr. President, I have had a time and a chance.
You have had the time and the chance to review them.
That is so.
Yes, the Chamber will require you, or we do require you to specifically advise the witness of those provisions. Have you done that so far?
Yes, I have, Mr. President.
Now, it is not the role of duty counsel appointed in these circumstances. It is not your role to direct or guide the testimony of the witness as to the merits of the case. The limitation, your mandate is simply what I've indicated, where the possibility of self-incrimination rises, to advise a witness to, as you said you've done, on the provisions of the rules as well as the Rome Statute, and also to be on standby in case that sort of possibility rises in the course of the testimony for you to intervene at that stage and help the witness make any observations or submissions, legal submissions that may need to be made at appropriate time. Also, very, very critical in this, in that task is to be on standby to signal to the court when an answer to a specific question might engage that possibility, so that we can go into private session to receive that answer. Ordinarily, it is the, or generally speaking, it is the task of the lawyer who's asking the question to signal that possibility, to tell us, well, we are now going in the direction or the territory of the possibility of self-incrimination, so that we will take the appropriate measures. So the prosecution would be on the lookout for that and would tell us when that possibility arises, as well as the defense counsel. But you're also there to assist in case there's been an omission to do so on the part of the questioners. Do you understand?
I do understand that, Mr. President.
All right.
And I'll be ready.
Thank you. Now, the prosecutor will have to advise us on possibilities of self-incrimination, and we will go into private session to receive any submissions the prosecutor may have. We'll go to private session now.
We're in open session, Mr. President.
Thank you. We will render 2 rulings on the matters discussed by Council. First ruling on Rule 74. And secondly, we will render our ruling on the in-court protective measures. After the ruling, we will adjourn and start back and return at 2:30 for the witnesses' testimony to commence in earnest. And that will give Mr. Karate time not only to advise the witness of the Chamber's ruling, and also the little more time he'd indicated he could have used. First, the ruling on Rule 74. The Chamber notes that an issue of self-incrimination may arise in the context of the anticipated testimony of witness 516. The Chamber has had the submissions and the undertakings by the prosecutor, and also we've had the views, to the extent that they expressed any views, put on the record by counsel for the defense, where issues of self-incrimination arise. The Chamber may, having consulted in particular with the prosecution, provide an assurance under Rule 74 of the Rules of Procedure and Evidence in order to enable a witness to testify truthfully without fear of the consequences of self-incrimination. As has been done in the past, this assurance is granted with respect to witness 516 under the same conditions as with previous witnesses. That is to say, in relation to Article 70, Sub 1, Clauses A and B, offences covered are offences committed in the phase of the court, in the course of testimony. Perjury, or giving evidence knowing the evidence to be false or forged. The Chamber does not absolve witnesses who come before it in relation to those specific offences, but where a witness comes to court and testifies truthfully or does not present false or forged evidence, that witness need not fear incurring liability under those 2 provisions. In relation to Article 70, Sub 1, Clause C, information provided by the witness during his testimony before this Chamber may not be used in any subsequent prosecution against him or her, directly or indirectly, in relation to the offence indicated in Article 70, Sub 1, Sub C. For any part of the testimony of this witness where issues of self-incrimination arise, the following measures will apply. The evidence shall be in private session or in closed session. The identity of the witness and the content of such confidential testimony shall not be disclosed in any manner. Counsel for the accused, as well as their clients, parties and participants, and court staff present, or persons who otherwise have access to the evidence or the testimony, are hereby specifically cautioned that breach of this order may result in sanctions under Article 71 of the Rome Statute. The relevant confidential transcripts of the evidence of this witness will be placed under seal, and the court will apply appropriate protective measures to any subsequent decisions in order to give effect to this order. As indicated when I was directing remarks to Mr. Karathe, it will be primarily the responsibility of the parties to ensure that all questioning which may touch on aspects of the witness's evidence likely to give rise to issues of self-incrimination is conducted in private or closed session. The witness or counsel on the witness's behalf may, in the same manner, also request private or closed session if it is anticipated that an answer to any particular question may give rise to self-incriminatory testimony. Counsel is directed to ensure that the witness is fully informed of and understands this ruling prior to the commencement of his testimony, the witness's testimony. Restrictions and contacts with witnesses during that testimony will apply in respect of witness 516. In particular, for the duration of his testimony, counsel assigned to him is only permitted contact with the witness on the conditions applicable to the legal representatives of dual status witnesses. Accordingly, counsel should refrain from holding any substantive discussions with the witness about the topics that are to be dealt with during his testimony or evidence that may be produced. But again, as indicated all along, the counsel for the witness has been retained for the specific purpose of advising the witness as regards Rule 74 or the possibility of self-incrimination and what may be done. For that reason, he may at any time confer with the witness to give him appropriate legal advice in that regard. It is also the ruling of the chamber that the basic principles of contact with witnesses as set out in the witness's preparation protocol shall apply in respect of any contact whether before or during the testimony of witness 516, including any contact with counsel. These principles prohibit coaching, training, or practicing of testimony, as well as any attempt to influence a witness to testify to factual events the witness did not observe or perceive. This concludes the ruling of this chamber at this time. On the second ruling on protective measures for the witness in the courtroom, the chamber notes that the prosecution had on the 28th of August 2014 filed the request for the usual suite of protective measures, specifically image and voice distortion, the use of pseudonyms, testimonies in private session when necessary, and redactions to public records were necessary to prevent identification of the witness. On the 5th of September 2014, the VWU provided its observations supporting the prosecutor's request, and noting in particular the circumstances in which this particular testimony is being taken. In particular, the witness is not here with us in the courtroom. I also note that the prosecution had indicated in their own submissions that the circumstances of the possibility of self-incrimination is also a matter to be taken into account in the Chamber's decision on protective measures during the testimony of the witness. The Chamber has heard the observations of parties and participants in the case, and the Chamber grants the request made by the prosecution. That concludes our ruling on that matter. We will adjourn now and come back at 2:30 for the testimony of the witness to start in substance, and during which time, during the intervening period, Mr. Kirate would have had more time to discuss with the witness or advise the witness, and specifically inform the witness of the Chamber's ruling.
There's one matter I can briefly raise, perhaps. It needn't detain the witness, nor Mr. Karathi, and in fact it would be better said perhaps with the connection severed, as it were.
We'll go to private session.
We're in open session, Mr. President.
As the Chamber will know, we receive copies of material in various degrees of redaction, and sometimes the same material in progressive degrees of unredaction. The position here is that we received the statement of this witness, 516. That's the statement that's KenyaMOJA.com 0087-0031. And the last version of that, which I was aware and working with, was RO5, version 5. Normally they go up to 2 or 3, but this one had achieved 5 as a point of further redaction. And we asked for the unredacted statement, not least of all because there were 2 redactions, or at least 2 redactions, in the version R05. And those redactions related to paragraph, I think it's 34. Let me just check on that. 36, rather. And also, and rather surprisingly, to paragraph 124, a token of which I can show you that from the bundle that was compiled for me from the documents that the prosecution were going to list in evidence, that particular page appears like that. You can see that the entire paragraph is blacked out.
Hold on. 1 second, Mr. Hooper. Something just occurred to me. Ms. Dumai, you can...
Yes, Mr. President.
You can, just in case, I remember when I told Mr. Karatu to step out, I said for a moment, he might be standing out there or sitting out waiting to come back in. No, he can move on now and do what he needs to do with his with the witness. We'll see him at 2:30.
Okay, sir, I'll tell him.
So coming to paragraph 134 from your site on the bench, you can see from what you saw when I displayed the page that that particular paragraph was still redacted. So we asked for, with this witness now imminent, for the prosecution to consider lifting that redaction or else place it again before the chamber. And we then last week received R06. I'm occupied with another witness. Over this weekend, placed my attention, of course, on the upcoming witness. I'm very surprised when I see the contents of 124, which, as far as the accused that we represent is concerned, is the high point of this witness's testimony. And so I'm asking the prosecution, through Your Honour, to explain why it was that this was redacted until just a few days ago, and what the explanation is for that, given their duties of disclosure and preeminently their duties of disclosure when it comes to incriminating material, because we, the defence, have not had an opportunity to investigate the allegation that's contained there. And what's particularly perhaps striking about it in the little that I've been able to uncover in any event is that witness 613 in her testimony, you may recall, was asked something about this subject, and as I understand it, clearly contradicts in her testimony, her evidence that she gave, the account that's contained in 124. I was deeply shocked and surprised when I saw the contents of that paragraph revealed. And it's also, the name was the redacted name. The name that appears in that paragraph is, again, the redacted name that appears in the much lesser redacted paragraph that appears at paragraph 36 that I referred to.
Yes. Hold on, Mr. Hoover. I ordinarily, speaking for myself, I try to avoid looking at witnesses' statements before they start testifying, because I want to have in my memory what the witness says in court. So, but now that you drawn our attention to paragraph 124, we don't even we have it redacted in the version we have, so we don't have paragraph 124.
Well, I was deeply surprised and shocked, and I don't like using hyperbole, but those were the, I think, two adjectives that I think would describe my reaction when I read that paragraph. Now, it might be that the prosecution have chosen not to rely on that paragraph, but if they haven't, then I'd ask the court to make it mandatory that they do ignore the contents of that paragraph, because service on the defence of incriminating evidence of that kind cannot be done at the relatively last moment. I don't know what the explanation is, and I dare say the prosecution may be able to present you with one. But I cannot see for the life of me what could possibly justify the position that the defence have now been placed in. And Your Honour, I'll say no more at the moment.
I think you've made that point very clear.
Yes. Thank you.
Thank you, Your Honours. The redactions in question deal specifically, and I bear in mind we're in public session, but with a particular former witness of the prosecutions, whom the prosecution decided not to call as a witness as a result of serious security concerns relating to that witness. And as much as we would have liked to have presented that witness to the court and evidence relating to that witness, the prosecution took a conscious decision not to rely on the evidence of that witness. The same goes for the paragraph which has been redacted. However, Your Honours are aware that as a result of it...
Are you saying then that you will not be relying on paragraph 124?
We will not be relying on paragraph 124 or any other matters relating to that former witness that are referred to in this statement.
Does that satisfy you?
Yes, it does.
Okay, maybe we should not prolong the debate then.
Yes.
Yes.
And
we'll leave it at that.
I can calm myself.
Yes. So hope you recover from the shock, hopefully.
And Your Honours, I would have been happy to have advised the defence had they asked me of that.
That's why it's always important to exchange views amongst counsel, and where matters are not resolved, then we can take them up before the chamber court would adjourn, and we come back at 2:30.
All rise.
All rise. We will away. Please be seated. We have verses 1.
We are in open session, Mr. President.
Thank you very much. Nairobi, you with us?
Yes, Mr. President, we're with you.
Thank you. And I do see the witness in the courtroom, in the on location in Nairobi. Is that the case?
Yes, Mr. President. The witness is in the transmission room.
All right, witness 516. Can you please administer the solemn declaration to the witness?
Yes, Mr. President.
Ninatamka kwa dhati ya kwamba nitasema ukweli.
The witness, I solemnly declare that I shall tell the truth, the whole truth, and nothing but the truth.
Witness, welcome and thank you for joining us. The last time we saw you was a brief introduction where I mentioned that you are appearing on the force of the summons that was issued to you because the prosecutor wanted you to appear and testify. Thank you for coming. I want to tell you up front that that summons that was issued to you remains binding upon you until your testimony has been completed and the chamber has discharged you. Do you understand?
Naelewa, Mr. President.
The witness, yes, Your Honor, I understand.
You are joining us today by way of video conference. That means effectively the courtroom has been extended from where we are in The Hague to where you are in Nairobi, and we thank you for joining us in the courtroom as such. And as I usually say to every witness who appear before the court, that this courtroom belongs to them. I say the same to you. It belongs to you. This is your courtroom as a member of the international community. And the reason I say that in particular is to reassure you to be comfortable while you are with us with your testimony, and do not feel like a stranger when you're here. This court belongs to you as much as it does to the judges here and as well as to the lawyers who will be asking you questions. So keep that in mind as you testify. Do you understand?
Nakuelewa, Mr. President.
The witness, yes, I understand you, Your Honor.
You are here to help us with our work in conducting inquiry into the post-election violence that occurred in Kenya at the end of 2007, beginning of 2008. The work we are to do, we will need your assistance very much in doing it. And the assistance we need from you is to answer questions that the lawyers in this case will ask you. Do you understand?
Ndio nakuelewa, Mr. President.
The witness, yes, I understand, Your Honor.
The first set of lawyers that will ask you questions, I would say the first lawyer that will ask you questions will be a prosecution lawyer who will ask you questions, and after the questions from the prosecutor, there will be questions from the defense lawyers. Mr. Ruto has his lawyers in here. So too does Mr. Singh. Each of lawyers from both teams would ask you questions after the prosecutor has finished asking you questions. Now, it is important that you concentrate and listen carefully to the question that each person would ask you, one question at a time. You understand the question and then you answer it. It is important that you listen carefully and make sure you understand the question you are being asked before you start answering. It may be that you have all the answers to those questions, and that is fine, so you give them to us in as brief a manner as possible. When you finish answering the question in as brief a manner as possible, but still full, then you will stop. One question at a time. This is important. Stop and wait for the next question to come. The way I'm speaking now, I'm speaking, as you will see, slowly, and that would also happen in the questioning that will happen that people will be asking you. The reason why we speak slowly is not that we cannot speak fast. It's just that because there are interpretations happening, interpretations of these questions you will be asked. And what happens sometimes is when the questioner slows down or stops, you may think that this is time for you to kick in and start answering the question. It may also be that you've finished answering the question and the questioner hasn't started asking you the next question immediately. This is the important one. You finish answering one question and the questioner has not started asking you the next question immediately. Then you may think that you've not said enough and you will continue. That is not the idea. The reason why the questioner didn't start asking you questions immediately is because of the interpretation that is going on. So the questioner is speaking slowly and pausing. So do not use that opportunity to keep on talking, feeling that you have not said enough. This is very important. I take time, I spend time on it because I want you to make sure that your answers are brief and to the point, and then you wait for the next question. Do you understand?
Inakuelewa, Mr. President.
The witness, I understand, Your Honor.
Some of the questions that the lawyers will ask you may appear difficult to you, and some may appear even pointless. Some may even appear to be repeating a question that has already been asked of you, to which you've already given an answer. Do not worry about those. Just take it one question at a time and answer that question. Give the information that the question calls for and stop and wait for the next question. Do not worry about whether or not the question is fair to you or whether the question is pointless. Keep on answering until I say no. Do not answer that particular question that is being asked of you. So this is very important for you to keep in mind as well. Do you understand?
Inakuelewa, Mr. President.
The witness, I understand, Your Honor.
I also need to stress to you about that matter of whether or not you are being treated fairly by the lawyers who are asking you questions, by the manner of the questions they ask you. This is a matter that the judges take very seriously. The judges do not like lawyers, and that has not happened in this courtroom, I must tell you also. But we do guard against witnesses being treated unfairly because they have come to court to obey the law and to respect the court, to sit and answer questions. We do not take it kindly if lawyers take the opportunity to be unfair to the witnesses. So we will make sure that you are protected from that point of view. And I also want to say, it has not been the practice in this courtroom for lawyers to do that sort of thing. Do you understand?
Naelewa, Mr. President.
The witness, yes, I understand, Your Honor.
One thing above all that we take the most seriously is to speak the truth. We require you to speak to us only what is the truth, as you know it. If you do not know the answer to a certain question, do not be shy to say you do not know. If you do not remember the answer, also you can say that. You can tell us you do not remember. It will be for the lawyers to see what they can do, to see if they can remind you of the information, if that is possible. But at all times, it is important that you focus on telling us the truth. Do you understand?
Ndio, nakuelewa, Mr. President.
The witness, yes, I understand, Your Honor.
And about speaking the truth, we've been told that your lawyer who's been assigned to be on hand during your testimony has already advised you that it is an offense under Article 70 of the Rome Statute to intentionally give false testimony to the chamber, knowing that you are giving false testimony. It is also an offense for you to present false or forged evidence to the chamber, knowing that the evidence is false or forged. All that goes to the point of stressing the need for you to tell the truth. You understand that?
Mr. President.
The witness, yes, I understand, Your Honor.
I also stress the need for you to concentrate on giving us information that you yourself know firsthand, things you saw yourself, or words you heard yourself. And if it is something you smelled yourself, assuming it's about smelling things that the question asked for, it has to be something that you yourself perceived with your own senses. Try to just give us that. Try to avoid guesswork or drawing inferences. When I say drawing inferences is when two things are put together and then one says because these two things are there, then the third thing must be the case, even though you do not or did not see the third thing yourself. So this is what I call drawing inferences. The example I use is in simple mathematics, 1 plus 1. So 1 plus 1 would be things that you would have known, and then equals 2 is the inference. Somebody said if 1 plus 1, then it has to be 2. Try not to give us the 2. Concentrate on 1 plus 1 that you yourself perceived. Do you understand what I'm saying?
Mr. President.
The witness, I understand, Your Honor.
Now, the court has granted the prosecutor's request that certain measures be put in place to enable your testimony to be taken with minimal stress to you and also to protect your identity. What those measures are, in essence, is we will not be your image, your face will not be broadcast to the public. Your voice also will not be heard directly to the public. The court has technology that's used to distort your image as well as your voice, so that members of the public who know you will not readily know that it is you who is testifying. We've also put in place, we've allowed that your real name be not used when you testify, but only your pseudonym will be used. And from time to time, it may be necessary to go into private session. That is when the public will not hear anything at all, not even your distorted voice. We go into private session to receive information that may be identifying of you. So these are basic measures we've put in place to make sure that your identity is not disclosed to the public. Now, but we hope that for the most part your testimony will be heard in public. That's your evidence will be heard in public, but without your identity being disclosed. When we are in the public session, it is important for you to avoid giving out information that may identify who you are, information like your name or names of relatives of yours or close friends. It's important that you do not mention those kinds of information when we're in a public session. Also, addresses of those people we don't want you to reveal in public. That includes your own address as well. In addition, there may be information that, although it is not a name or address, could be a story, an event that is very unique, that somebody listening in public might say it could only be you that would know that information. So that sort of information we should also not give in the public session. That is why we have the private session. It does not mean that names or addresses or those sorts of unique information I mentioned may not be given at all by you in your testimony. It only means we will do that in private session. Do you understand?
Mr. President.
The witness. Yes, I do understand, Mr. President.
So please keep that in mind when we're in the public session and a question has been asked of you that may lead to you mentioning names or addresses of people close to you or unique information. Be sure to keep in mind to draw my attention to it and request for us to go into private session so you can speak freely on the information. Now, there is a very important aspect of the advice I'll have to give to you that makes our work go well. That is how you speak. As I said some time ago, that I'm speaking slowly. I also mentioned that there are gaps that lawyers would observe. I need to talk to you about that. We have interpreters and court reporters who do their work. Without their work, we cannot do ours successfully. Your testimony will not be properly recorded. So they're here to help us keep record of the proceedings, and we will like you to assist in making their work easy for them, as easy as possible. That requires you to not speak too fast during your testimony. That does not mean you speak very, very slowly. To speak at a moderate pace. There's also another part to that, useful information. That is the pause you need to take between the end of the question being asked of you and you beginning to answer it. We need you to observe a 5-second pause. You observe that by counting to 5 in your mind, like this. 1, 2, 3, 4, 5. And then you start answering. That pause of 5 seconds will make sure that there are not two people overlapping on the microphone. Your microphone over there and mine over here, and the microphones of the lawyers who are asking you questions. It is only through the microphones that the interpreters can hear you and the court reporters can hear you, to both interpret what you're saying and to record what you've said. We do not want to crowd the microphone with two people speaking at once. That is why the 5 seconds pause is important. When you observe it, it makes sure that there's enough time for the interpreters to finish interpreting before the next person starts talking, and that frees up the time, the space on the microphone for your testimony to be captured properly. So please keep that in mind. From time to time, I may be reminding you of the need to remember this advice, but it is very, very important for our work. Do you understand? You need to speak slowly, but not too slowly. You also need to wait for 5 seconds between the time somebody has finished asking you a question and the time you begin to answer the question. I need you to observe, to wait for 5 seconds. As I said, I counted 1, 2, 3, 4, 5. And then you can start answering. Do you understand that?
Nimekuelewa, Mr. President.
The witness. Mr. President, I understand you now.
Yes, thank you. So you observe those count to 5 in your mind. Count to 5 in your mind between the end of the question and then you're beginning to answer it. And then once you start answering, you then speak slowly, not too fast. That is the point I was trying to make. All right?
Ndio nakuelewa, Mr. President.
The witness. I understand you, Mr. President.
And finally, there's a lawyer standing by with you there. I see him sitting and taking notes. The reason why we appointed him to assist you or to be on standby is because there may be times during your testimony when a question might arise, whether the answer you will give to a particular question might incriminate you in a crime. That is why we have Mr. Kanate? Mr. Wandugi, I forget that. Can you please?
Wandugi Karate.
Karate, I think.
Mr. Karate.
That's right.
I'm sorry about that. Sorry, Mr. Karate. It's on hand to assist you when the time comes up and there's some concern that an answer you give may incriminate you. He will assist with any intervention, but be also on the lookout for such questions to indicate to the court that that possibility exists, that if you give an answer in the manner the question was asked, it might incriminate you. Mr. Karate would then be assisting with any submissions that may be made in that regard. He will also require us going into private session if we're in public session for that answer to be given. I understand that Mr. Karate has already advised you of what the legal position is, what the statutes of the court and the rules say on that matter. Is that correct?
Mr. President.
The witness. Yes, Mr. President.
All right. With all that out of the way, I will now hand you over to the prosecutor who will start questioning you. Mr. Steinberg?
Yes, Mr. Khan points out transcript page 54, line 7 and 8. It might need a correction. We're not sure, but we think it probably does.
Your Honour, the line, of course, the judges do not like lawyers. I'm sure it's not meant.
I'm sure you know that's not what was meant. All right. Judges very much like lawyers. Judges are lawyers too. So we will now have Mr. Steinberg start his questioning.
Thank you, Your Honours. Before I do, perhaps, one preliminary matter. I notice that the witness has thus far been utilising the assistance of an interpreter. Much like the last witness, Your Honours, this witness also conducted his interview with the OTP in English and provided a statement in English. So I wonder whether he might be able to assist us, at least initially, by giving his evidence in English with the proviso that the interpreter is on standby to assist him if necessary.
Witness, that is an important matter that the prosecutor has raised, and I thank him for reminding me of that. I was actually going to also discuss it with you. We note that you are now speaking to us in Swahili, and we understand that that is your preference. We understand why witnesses who come to court may want to testify in a language they feel the most comfortable in. In this case, that would be Swahili for you as compared to English. We would urge you to do your best to testify in English, and the reason for that is that things would move a little faster and we can finish sooner, and you will be done with your testimony much sooner. Also, and this is very, very important, apart from speed, it would also avoid any arguments or confusion about interpretation, whether what you said in Swahili has been correctly interpreted into English. It is for that reason that we encourage witnesses who are proficient enough in the English language to testify in English. We are not going to lock you out of Swahili altogether. The idea is not to say, well, you must testify in Swahili all through. In English all through. You can start in English, and if there is some serious difficulty encountered from time to time for which you feel that it is best for you to testify, express yourself more fully in Swahili, we will accommodate that situation. Do you understand?
Nakuelewa, Mr. President.
The witness. Yes, I understand, Mr. President.
So if we can...
Can I say something, Mr. President?
May.
Can I say something, Mr. President?
Yes, proceed.
Ombi langu wakati tulipoongea na wewe nilikuwa nimesema nitoe kwa Kiswahili.
The witness. When I had a discussion with you, I expressed the desire to testify in Kiswahili, which is the language that I understand the most.
Is that what you wanted to remind me of, or what you wanted to tell me?
Yes, Mr. President.
Your Honour, may I, sorry to intervene, but...
The witness, yes, Mr. President.
...of help, because there's a slight implication in the way my friend dealt with this matter, which I noticed that in previous dealings with this witness, interpreters have been used. And indeed, I can see from the transcript that I have, prosecution transcript for December.
But Mr. Hooper, one second.
Yes.
I wasn't really taken by whether or not the interpreter had been used by the prosecutor in the past.
It's not that. It's 2013. And this is the problems with the line, but the OTP representative on that occasion, who I think is I won't mention his name, says, "I'm having real trouble understanding you," mentions the witness's name. It might be the case that I ring back later, maybe with an interpreter. Do you speak Swahili? He says, yes. He says, okay, I might try to arrange a bit later on, possibly, to speak with you with an interpreter. And the witness says, yes, it is better if you bring someone so we can talk Kiswahili, because English is not good for me. And the interviewer says, yeah, I'm having trouble understanding you. The line's not too clear. Blah, blah. Is there another number as well? So I'm just putting that there's a history of this witness's expressing anxieties about having to be limited to English.
All right. Mr. Hooper, the court officer is saying that there was technical difficulty with the French booth hearing you. So they didn't hear what you said in your last intervention. So everything you said wasn't captured. If I may summarize, the sum of it is that Mr. Hooper pointed out that the records indicate that the OTP investigator did have difficulty with the witness on the matter of language, that the witness during interviews had expressed difficulty with English then, and the interpreter the investigator or the interviewer did appear to have noticed that herself and say that she would arrange for an interpreter to be on hand for subsequent interviews, and the witness agreed with that. That is the point of the sum of what Mr. Hooper had said. We'll leave it at that. Witness, let's do this. But you can understand English, can you? Even if you may have difficulty communicating in English?
Mr. President, kwa kiwango kidogo. Si ya kuridhisha.
The witness, yes, I do understand some English. A little bit of English.
All right, let's do this. Mrs. Steinbach will start his questions and see how we go. He will ask you questions in English and try to listen to him in English. If you are having difficulty understanding him in English, tell us immediately. He will speak to you in English, and then you're free to answer in English or in Kiswahili. Do you understand?
Nakuelewa, Mr. President.
The witness, yes, I do, Mr. President.
But if you also have difficulty understanding his English, also tell us immediately. We do not want you to answer a question that you did not understand. Do you understand what I'm saying?
Nakuelewa, Mr. President.
Witness, yes, I do understand, Mr. President.
Mr. Steinberg, let's start. You have to be as simple as possible in your English so that the witness can understand. That's why I've also tried to speak in a similar way. I do not know if I succeeded, but I tried.
Thank you, Your Honor. Similarly, I will try my best. Good afternoon, Mr. Witness.
Good afternoon, sir.
Before I start putting questions to you relating to your knowledge of the events in 2007 and 2008 for which you've been called to testify, I'd just like to confirm that one thing. Is it correct that the representatives of the Victims and Witnesses Unit asked you if you would be prepared to undergo witness preparation with the prosecution? Is that correct?
It's correct, sir.
And what was your response to that invitation, Mr. Witness?
It was yes.
Can I just confirm that you said that you were prepared to undergo witness preparation with members of the prosecution?
Yes, sir.
Because what was conveyed to us was that you did not want to undergo such preparation. Is that not right?
Yes, but I had some little problems, so that's why that made me to say so.
So the problems that you had made you say what exactly?
Because when they were... Can I talk in Kiswahili? Please.
Go ahead.
Wakati waliponihoji nitoe ushahidi.
When I was asked to testify,
I understand that. What I'm speaking about is not your testimony itself. My question related to a request to meet with the prosecution before your testimony in order to familiarize you with your evidence before you got into the witness box. You understand?
Yes, Mr. President asked me if I should... I don't know. Mr. President aliniuliza kama unataka tupatane na majaji au watu ya VW. Nikasema nataka nipatane.
The President asked me whether I wanted to meet the VW staff or staff from the OTP.
Yes, and what did you choose?
I chose VW.
Thank you very much. Your Honours, at the outset I would like to place on record certain personal particulars of the witness, which in their nature will be identifying. Therefore, as usual, may I ask that we go into private session. I expect that we can wrap this up in approximately 10 minutes.
Private session.
We are in open session, Mr. President.
Thank you. Mr. Witness, before you continue with that explanation, I'll come back to that in a moment, but I'd just like to explain to you certain procedures I'm going to ask you to follow in order to protect the protective measures that the Chamber has granted to you. And I would ask the court officer please to call up page 2 of the protected information sheet for the witness to see and confirm when that's done.
Mr. Steinberg, a paper copy of page 2 of the PIS is shown.
All right, Mr. Witness, as we're going through your evidence, it may be necessary to refer to certain locations.
Mr. Steinberg, we need to take that again, not from your end, but from the court officer's end. There's something that ended indecisible. We want the matter to be clear on the record. Court officer in Nairobi, you said, Mr. Steinberg, a paper copy of page 2 of the PIS, and then we did not, the record did not get the rest of what you said.
A paper copy of page 2 has been presented to the witness.
Thank you.
Thank you, Your Honor. Mr. Witness, as I was saying, if you look at the page in front of you, there are various places and names of people, so locations and people, that you might need to refer to in the course of your evidence. And if we are in public session, particularly in public session, I would ask you not to mention those names and places, since they might identify you to members of the public. Do you understand?
Si utarudia hapo sababu sijaelewa wakati gani niko.
Answer: no, I haven't really understood what you said. Could you please repeat?
All right. Let's look at the first item on the page under the heading locations. Without reading it out loud, because we're in public session, do you see the name of that place?
Ndivyo.
Answer: yes.
If in the course of your evidence you need to refer to that place, please don't say it out loud. Rather refer to location number 1. Do you follow?
Ndivyo.
Answer: yes.
And similarly, also, if you need to refer to any of the persons listed below numbers 1 to 12, could you please refer to them as person number 1, person number 2, person number 3, and so on? Understand?
Ndivyo.
All right.
Answer: yes.
All right, thank you. Now, let's go back to the explanation you started to give to the Chamber regarding the circumstances under which you came to sign a statement before the OTP. Perhaps we can first start by just identifying the actual statement that you signed. Madam Court Officer, I'm not sure whether you have a paper copy or an electronic copy of that statement available. Can you please confirm which you have and also which revision you have?
Mr. Steinberg, I have a paper copy of document KenyaMOJA.com 0087 0031. It's a redacted version, but I'm unsure which redacted version it is. I can, however, confirm that some paragraphs are blackened.
Can you just confirm whether paragraph 124 is redacted? That will help us.
Yes, it is.
All right, then I think you have revision 5, which will be fine for present purposes. So, Mr. Witness, can I ask you please to look at the front page of that document that the court officer is showing you? Do you have that in front of you now?
I see the time. So perhaps this is just a brief moment. Are we going to ask the witness what his account is? Or is my friend choosing to go straight to the statement? And why is the PIS form headed by the name of someone who doesn't feature in the evidence at all? And indeed, number 3 on the list is someone who doesn't feature in the evidence. And it's rather telling that the prosecution is approaching a witness in this particular way. Wouldn't it be better to ask the witness what his account is and come about in that way?
May I start by correcting my learned friend? Both of those persons are distinctly mentioned in the statement. I refer to paragraphs 19 and 20. I do indeed intend to ask the witness to give his account. I just wanted to identify the statement we were talking about, and I do not intend to go to the contents, but as we've done in the past, simply get him to identify his signatures thereon. Perhaps we can just wrap up at that issue, and then we can move on in the morning. Mr. Witness, do you recognize this document that's being shown to you?
No.
Sir, no.
Rudia tena, sikuja kuelewa.
The witness, please repeat your question.
Yes, my question was, do you recognize the document, the statement that's being shown to you by the court officer? Have you seen this before?